Welcome to The Explainer. Let's dive right in. Today, we're exploring the strict, honestly pretty cutthroat mechanics of attorney disqualification. We're going to do this by examining a very real, very meticulous motion that was filed in a Texas probate court. If you've ever wondered how you actually remove an opposing attorney from a case because of a conflict of interest, well, you're about to see it firsthand. It's not just about throwing allegations around. It is entirely about building an absolute, undeniable paper trail.
To really understand this legal maneuver, here's our roadmap for The Explainer. First, we'll hit the disqualification legal standard. Then we'll break down the three core elements: prior representation, adverse interests, and related matter. And finally, we'll look at the ultimate knockout punch, the irrefutable presumption.
All right, part one, the disqualification legal standard.
Down in Texas, the main battlefield for conflicts of interest is Rule 1.09. Basically, you can't just switch sides and use what you learned against a former client. It's common sense, right? But this rule creates a very strict three-part test. You need to prove a prior attorney-client relationship, a subsequent adverse representation, and that it involves the same, or at least a substantially related, matter. If you hit all three of those, the lawyer is out.
Now, what is truly fascinating here is how the pro se litigant, Kenneth Michael Crabtree, actually mapped out this exact matrix in his evidence package. He didn't just throw a bunch of papers at the wall and hope something stuck. He created a literal checklist for the judge, matching the legal requirement directly to the specific document in his filing. This right here is exactly how you structure a winning argument. You make it incredibly easy for the court to see your proof.
Let's move on to element 1, prior representation.
The whole motion hinges on proving that attorney Karen Kish previously represented Kenneth. And the documentary evidence here? It starts right with the receipts. Specifically, a November 17th email with the subject line, "Urgent clarification of representation." Kenneth is calling out the conflict in writing, immediately after discovering the firm was treating his brother as the primary client while excluding him. This clearly establishes the relationship and the prompt objection to what was happening.
And then we get the final fracture. After 4 days of alleged radio silence from the attorney, and let's be honest, nobody likes getting ghosted, especially by their own lawyer, Kenneth sends a time-stamped termination email on November 21st. Effective immediately, I am terminating your firm's representation. Boom! Element 1 is firmly locked in. The attorney-client relationship absolutely existed, and it was formally terminated on this exact date.
So that brings us to element 2, adverse interests. This is where the plot really thickens. The former lawyer reappears, but now she's representing Kenneth's brother, Christopher. They file a claim seeking a fiduciary role directly opposed to Kenneth's own appointment as executor in their mother's will. So this isn't just some casual family disagreement. It is a formal legal attempt to strip a former client of his designated role. That is absolutely textbook adversity.
To prove this adverse stance, the evidence package highlights a pretty stark documentary contradiction. The attorney files a claim stating Kenneth refused to serve. But look at the time-stamped reality. There's an email from Kenneth just days prior explicitly stating, "I have decided that I am willing to serve as executor." So the adverse filing directly contradicted evidence sitting right there in the attorney's own inbox.
When you look at this rapid-fire timeline, the paper trail becomes impossible to ignore. From the urgent notice in mid-November to the formal termination, to affirming his intent to serve, and finally, the adverse application filed in the probate court in late February. By laying it all out chronologically like this, the transition from former counsel to adverse counsel is just perfectly clear.
Okay, element 3, related matter.
So we have a former relationship, and we have adversity. The final hurdle is proving the new case is a substantially related matter, meaning confidential info could be unfairly used. The evidence here is arguably the strongest variant you could possibly have. Why? Because it's literally the exact same estate, the Parks estate and the Fitchhugh estate. We're talking the exact same will, the exact same involved parties, and the same confidential communications. As Kenneth's filing so bluntly puts it, there can be no serious dispute that the subject matter of the prior representation and current litigation are substantially related because they are the same case. You really cannot get more substantially related than operating within the confines of the exact same case file. When the case numbers match up like that, element 3 is effectively a slam dunk.
Which brings us to the ultimate consequence, the irrefutable presumption.
So, what happens when all three of these elements are proven with cold, hard emails and court filings? Well, you trigger what Texas law calls the irrefutable presumption.
Based on Supreme Court precedent, the court doesn't even ask if the lawyer actually spilled your secrets. The law just automatically assumes they did, and the opposing side isn't even allowed to argue against it. No debate, no defense.
The Texas Supreme Court explains exactly why this is so strict in the Fedford case. The mere appearance of impropriety threatens the entire integrity of the judicial system. Even a tiny, microscopic risk that confidential information could be used against a former client demands that the trial court disqualify counsel. The remedy is incredibly severe, and more importantly, it is mandatory.
And the consequences are massive. This motion isn't asking for a simple slap on the wrist. It seeks to completely disqualify the attorney, remove her entire law firm, strike all their recent paperwork filed after the conflict arose, and slap them with a financial penalty for making the motion necessary in the first place. It's a total, ground-up reset of the opponent's strategy. When reviewing the anatomy of this motion, it really leaves us with a powerful takeaway. The next time you find yourself in a professional dispute, ask yourself, are you just throwing out allegations, or are you building an undeniable, meticulously time-stamped paper trail? Because as this motion definitively proves, whoever has the receipts usually holds the power. Thanks so much for joining me on this explainer.